Okay, so now we know how legislation is created by Congress, and we know how the goals and policy and broad frameworks are turned into something more specific by regulations, by the different federal agencies. And so these laws will go on to live for a long time. We looked at one of the original transportation bills that was written in 1966. And the Fair Motor Vehicle Safety Standards, some of those have been there for decades. So some of these regulations and laws are quite old, and sometimes they're written at the time, they're vague, and even if they're not, over time they become a little vague, and we're not sure how to interpret them because society has changed or the technology has changed. And so that's when we talk about how do we interpret statutes and regulations. And this is the ambit of the judiciary, the third branch of government. So we have federal courts that will take a look at the law and take a look at the situation and figure out exactly how to apply it. So, for example, I'll give you an example right now with automated vehicles, right? A lot of the legislation and rules and regulations that come out of that legislation refer to drivers, right? At the time, driver meant, we all knew what driver meant, but what does that mean now with highly automated vehicles? Is the car a driver? That is subject to interpretation. And that's what we mean when we talk about statutory or regulatory interpretation. And I have this book here because just to know there's an entire law school class around how to interpret laws and regulations. But we will talk big picture here, and I'll point out some of the key issues that you need to know. So, when it comes to statutory interpretation by the courts, there are a few different avenues. So this is the process to determine the meaning of the laws. Deciding how to apply, we often look at different methods and tools, and some of those include textualism, legislative intent, and canons of construction. So what does that mean? So textualism is a method of interpreting a law where the text is the end all be all. It focuses just on the text of the statute. So if you are a textualist, you believe that the words of the statute should be interpreted according to their ordinary meaning at the time the law was passed. Without considering intentions or motivations, you only look at the text. So when we look at the example of drivers, and we're trying to figure out, well, does that apply to computer drivers, to automated driving systems? Is that a driver? A textualist would say no. The textualist would look at the law and say, when they wrote this, yeah, they didn't know about automated vehicles, but it doesn't matter. They were talking about human drivers, and so therefore we will only interpret drivers to mean human drivers. We won't think about what was their intent or what would they have done had they known about highly automated driving. We're only looking at the text. So that is textualism. It should be noted that judges tend to stick to one type. So if they are a textualist, they will be that way every single time that they look at a law. It's not like for one law, I'll be a textualist, and then for another law, I'm going to think about the intention of the drafters. Obviously there's nuance there, but you tend to have a judge that's like known to be a textualist or known to be, known to look at intention or consider other things. So, but that's what textualism is. The idea is that the text is law and that it's clear, and that should be the end and the beginning. An example of this is Bostock v. Clayton County in 2020. The U.S. Supreme Court was looking at the Civil Rights Act, which prohibits discrimination because of sex, and they found it also applied to sex orientation or sexual orientation as well. They just interpreted the plain meaning of because of sex to include gender identity, even though lawmakers in 1964 didn't necessarily foresee that application, but to them that was, if they go back and look to the original meaning of that word, it doesn't matter what intent is. So that is an example of textualism. The next way to look at things is legislative intent. And so legislative intent seeks to understand the purpose. So this is going to be the little bit opposite of textualism in some way. It's we're trying to understand, what did Congress intend to do, right? If we can't figure it out from the text, let's look at what else was going on at the time. Let's look at that legislative history that we talked about, such as committee reports, debates, other records, the hearings, to try to figure out, what did the lawmakers mean. We're looking beyond the text and looking at the circumstances and other things that were said at the time, but maybe that didn't make it into the bill. And so the key idea here is that the law should be applied in a way that furthers the purpose of Congress that they had in mind when they passed it. So if we go back to the driver's issue, right, and the statute refers to drivers and the regulation refers to drivers. And yeah, drivers usually means humans, but they didn't know about automated vehicles then. And if they had known, they meant for this to regulate whatever or whoever was operating the vehicle, whether it's a human driver or a system. And so someone who looks at legislative intent might find authority for that, might find evidence of what I just said in that legislative history. And so they will interpret the law in that way, even if it's not clear from the text. So a well-known example of this that you might learn in law school would be the Church of Holy Trinity versus U.S. This is way back in 1892, very old case. And there was, we were going through some, nativism, and the federal law prohibited foreign workers from coming in to perform labor in the United States. This is a very protectionist measure. And a church had hired a minister from England. And the U.S. government said, it's a violation of law. That's a job, and that's someone who's not, that's someone from another country, so you're violating the law. Now, so the plain text said that you can't hire people from outside of the United States. And technically, it would have applied to a minister. But the Supreme Court looked at the legislative intent of the statute. And the purpose behind the law was to prevent, unskilled manual laborers, not professionals like ministers. And the legislative history showed that Congress was concerned about protecting U.S. jobs from an influx of low-wage workers. They weren't worried about religious leaders. And so they ruled against the government and allowed that church to hire the minister from England. So by the words of the law, by the text, they could not hire that minister. But looking at the legislative intent, yes, they could. And so that's an example of, how text versus intent can really matter. And it comes down to the personal preference of the judge, right? So there's not a right way or wrong way. It is, these are the kind of things that presidents think about when they appoint justices to the Supreme Court, for example, or, lower level courts. So that's just something to consider. The third tool that you might have at your disposal when you are interpreting statutes are called canons of construction. And these are just kind of like established rules or principles that guide judges in interpreting ambiguous or unclear statutory language. And you can divide this into two groups. There's linguistic canons. This helps clarify the meaning of language. And then there's substantive canons. And so these are going to reflect broader legal principles or policy preferences. But the idea is this is a structured way to resolve ambiguities based on common use of language or legal principles. So I'll give you an example. I'm not going to say the Latin word for this. They're difficult for me to say. But there's one canon that's Latin for of the same kind. And so if a law lists a specific list of items and then refers to other things, then that term other things is interpreted to include only items similar to the ones already listed. So for example, this is an example below. I thought this would be helpful. If the law says something like cars, trucks, motorcycles, and other vehicles, well, using this, canon of construction, we would interpret other vehicles to mean just other similar motorized vehicles, maybe mopeds or electric bikes, but not like airplanes, right? helicopters, tanks, or whatever, right? Which if you just use the word vehicle and we use a dictionary definition, that can cover a lot, right? But cars, trucks, motorcycles, and other vehicles, we're only going to put other, motorized vehicles that are, somewhat similar, right? So that's a canon of construction. By itself, other vehicles, we don't know what that means. But since it's in this list, we're gonna get some context from the list. That's one canon of construction. Another one would be the expression of one thing excludes the others. So if a statute explicitly mentions specific things, it is implying that other similar things are not included. So if a statute says fruits such as apples, bananas, and oranges, it may imply that other fruits like grapes are not covered by the law. So again, they're making a list for a specific reason. Sometimes it's to give us an idea for context. Sometimes it's exclusive. And so those are different canons, those are tools that judges can use to help them out with figuring out what an ambiguous text means. And it usually makes sense when you're in the context of a specific law. Next was the Chevron deference, which actually was just very recently overturned. But the Chevron deference basically said courts are going to defer to the federal agencies when they interpret their own ambiguous statutes, right? So if the statute's ambiguous and the agency has a way of interpreting that ambiguous statute, the courts are going to say, you know what, they're probably right. We'll just defer to them. This is their territory. And so it was you deferred to the agency unless the interpretation was just on its face unreasonable. That was overturned very recently. And so the courts may still apply what we call the Skidmore deference, which it means the agency's interpretations are given some persuasive weight based on expertise, but there's no full-on deference. And this was a big shock to the legal community because this Chevron deference has been around for a long time. But you're starting to see, especially with like the EPA and more recently the FDA, the Supreme Court is willing to, rethink some of the interpretations or decisions made by those agencies, even though those agencies are typically filled with experts. And so I mentioned the Chevron deference here because it's been around for a long time and you might hear reference to it, but it has been overturned as of this year. And then finally, judicial review of regulations. So, again, judges can, looking through it, there's an arbitrary and capricious standard. So courts are going to look at, is an agency's regulation just completely arbitrary, capricious, not accordance of the law? And if an agency exceeds its statutory authority, then the regulation can be struck down. So these other tools and methods I've talked about are for interpreting statutes and regulations, but judges also, they don't just interpret, they also can strike them down as well.